So the hour being 11 o'clock, I'll call this meeting of the Chelmsford Board of Assessors to order. It is Thursday, July 9th, 2020. And I will read the obligatory statement. Pursuant to Governor Baker's March 12, 2020 order suspending certain provisions of the open meeting law, General Law, Chapter 30A, Section 18, and the Governor's March 15, 2020 order imposing strict limitation on the number of people that may gather in one place, this meeting of the Town of Chelmsford Board of Assessors will be conducted via remote participation to the greatest extent possible. No in-person attendance of members of the public will be permitted, but every effort will be made to ensure that the public can adequately access the proceedings in real time via technological means. In the event that we are unable to do so, despite best efforts, we will post on the town's website an audio or video recording, transcript, or other comprehensive record of proceedings as soon as possible after the meeting. Okay, so why don't we start with the approval of minutes, and we have approval of our June 19th, 2020 minutes. Do I hear a motion?
Motion to approve the June 19th, 2020 minutes.
Okay, second.
Aye. Second.
Okay, we have a motion by Jack and a second by Kevin to approve the June 19th, 2020 minutes. All those in favor, please say aye.
Aye.
Aye, unanimous, thank you. Okay, we also have executive session minutes. And just by way of information, we discussed this at our last meeting. I said I would check with the Attorney General to see if our understanding relative to when it is appropriate to go into executive session is accurate. And we had a discussion. Jack indicated or said he thought that the actual documents that are confidential and would be the basis really for the executive sessions would not become a permanent file record, and we think that's accurate. I did check with the AG, but they have not yet gotten back to me. So until such time as they do, we will proceed on our assumption as discussed at our June 19th meeting. I think that's a safe thing to do. If we're wrong, we can change it upon advice of the AG. So we'll do that. We have two sets of minutes to approve. And I believe, Frank, you can keep us straight on this. On both the April 24th and the April 30th minutes of this year, I believe those matters are largely resolved.
Yes.
Okay, so it would be appropriate to approve those for public release. So could I have a motion, please, to approve the April 24th minutes as written?
I don't think I was there.
Okay, so you, all right. I think that's right. I don't think you were at either of those meetings, Jack.
Yeah.
So you can recuse yourself from that, from this process. So if I have a motion from Kevin.
Yes, but I have a question too.
Go ahead.
Has the appeal period expired? Is there an appeal period once there's been a settlement? Do you know, Frank?
I don't think either of those
Technology
minutes.
Drive ones, am I correct?
Yeah.
They withdrew their appeals at the appellate tax board. They had one for the previous year that was withdrawn once we had settled. Technically, I suppose for fiscal 20, they could continue until they're typically, and what's happened in this case, when I've notified them that we've settled the appeal, meaning the appellant, until they receive a certificate and or a check from us, they continue, in this case, they went on to continue to file at the impact tax board to protect their client. But it's understood that it's been settled. They're just moving forward, once again, to protect their client in terms of filing a formal appeal until they actually have the certificate and the check.
So there's an agreement to settle, but it's not finalized yet, is that?
It is. I don't know if the certificate's gone out as we speak.
I don't think we should.
You want to hold off on that?
I think
That's
we
fine.
should.
All right.
Certainly, the attorney looks at it like that, of the appellant, that until he or she receives it.
It probably won't matter in the end,
No,
but
right. That's how I look at it.
I think.
What do you think, Jack?
I would wait until we absolutely know for sure it's
All right.
done.
Yeah, I agree. I have no issues with that.
Okay, so we're not going to release the April 24th minutes pending resolution of appeal. Okay, what about 4:30? The April 30th minutes. Do we have any issue like that, Frank?
I don't believe so. I'm gonna take a look at it now. Bear with me. I don't believe so. Those were
All right.
almost straightforward.
All right. Do we have a motion to release the April 30th minutes? Are we looking?
I'm bringing it up now to refresh my memory, but
Okay. Well, Kevin's the attorney, so we'll rely on his advice.
well, they're all fiscal 20. There's nothing preventing them from filing at the appellate tax board, whether they received an abatement or not.
All right.
So following that same line of thinking for the earlier one, maybe we should hold off.
Okay.
The problem
well,
is, I was just saying before you came on board, Sam, that the appellate tax board appears to be extending the date for filing at the ATB. It was an August 1st date that we'd be looking to for many of these,
mhm.
but they're moving it out to a date that's yet to be determined. They may not be coming back to their office till after the first of the year, which is from what I'm hearing for a number of state offices. I don't know if that's true of this ATB, but I know in talking to the DOR, that's the kind of time frame that they're looking at. As much as anything to do with the configuration of the buildings and not being able to accommodate the 6-foot distancing and all of that. The ATB is a little bit different. I've been in the building; they can get away with it. But when they're going to reconvene, I have no idea.
But that doesn't, I mean, and certainly we have to recognize that, but that doesn't change the logic of what we just talked
It does
about.
not. It
I
just
mean, the
makes
appeal is still pending and there's no limitation, there's no
Correct.
expiration date on the appeal timeframe.
not a date certain. No.
All right, so are we okay with that? Not releasing those?
Yeah.
Okay, good. I'm glad we had that discussion. I think that clarifies it for me anyway. So,
Yeah.
and if anybody questions it, well, that's fine. They can file a request with the Attorney General and
We discussed it and gave our reasons.
Right.
and it'll be documented in the minutes what our rationale is, and if somebody takes issue with that, that's fine, and we'll do as guided by the appropriate authority. So I don't have a problem with that. All right, good. No appointments, correct?
None. Correct.
All right. What's next? Do we need are we all set, Frank, for an executive session, or?
The only thing I have to discuss, Sam, is one abatement that we denied, that it would kind of take another look at, an exemption that we acted on last time, that I would want, just for full disclosure, want to explain it. To the extent that belongs in executive session, I don't know.
If we're going to review the vision report you sent over,
Yeah,
I mean, that was their I&E was in that.
sure was.
Yeah.
Good point, Jack.
Yep. So probably both those things should be in executive session.
Right.
All right, so do we have any other regular meeting business to discuss?
I have nothing.
All right, so let me just get the time here. That
I
was
just want to
quick.
alert Dan of the procedure now. This kind of cuts off the public input, Sam, right? Dan is monitoring the answers and the host of this. You still with us, Dan? Did he leave us?
No, I'm here.
Okay. Typically what Pete would do at this point is to enter into executive session. He would continue to monitor the meeting. However, he cuts off the recording that will appear on Chelmsford Telemedia or wherever. So that's, so the part from now looking forward won't be part of the publication. Is that accurate, Sam?
As soon as we have an approved motion, right?
Yeah, let me read the motion. So we have a motion. We have a motion by Mr. Sullivan to adjourn to executive session pursuant to Mass General Law, Chapter 30A, Section 21A7, to comply with or act under the authority of Any general law specifically to require confidentiality is defined in Mass General Law, Chapter 59, Section 60. Records of abatements in Chapter 214, Section 1B, right of privacy, to discuss abatement and/or hardship exemptions as required, and further to discuss strategy with respect to pending litigation, not to return to open session. Do we have a second from Jack?
Seconded.
Okay. Motion and second, and we'll poll the board. Mr. Sullivan,
Aye, I'm in favor.
Mr. Duffett,
Aye.
and the chair votes aye. We are now adjourned into executive session. Time is 11:11 a.m. Okay, good.